Hi, everyone. Harry here to talk about a finding on the facts that Donald Trump is a rapist. Okay, now that's a very sensational sentence I just uttered, but I think I can back it up. We are in the E. Jean Carroll trial. And recall that trial, the sexual assault charges went to trial first, as opposed to the defamation, because New York passed this special law that says survivors of sexual assault had an extra year if they hadn't brought their allegations. And E. Jean Carroll's episode with Trump in the Bergdorf Goodman department store happened in 1991. She took advantage of this window to bring the charges. Now, the charges, there's both defamation and sexual abuse, and she was not required for the sexual abuse charge to prove rape. She just had to prove sexual abuse under New York law. But her allegations, in fact, amounted to rape. She alleged that Trump penetrated her in the dressing room. So it went to the jury, and the jury just needed to agree on a theory that constituted sexual abuse under New York law. And there was one juror who wasn't so certain that rape had been proven. She testified. It was still a little bit of, I don't know if it would be fogginess as much as uncertainty as to whether there'd actually been penile penetration. But the jury just said, look, it doesn't matter. The other 11 said, look, we'll just go with a sexual abuse theory. We don't need to find rape. We'll go with the what's clearly a sexual abuse based on the least the facts could be. And then with that finding, they were able to hold for her, so it didn't really matter. Trump, in his brazen and self-defeating way, here we have, him really shooting himself in the foot if there were any, toes left to shoot off. But he takes this, not, there's no finding of no rape. They just decline to find rape and they go on sexual abuse. So he takes the fact that the jury didn't find for rape. First, he has sued her for defamation, saying she accused him of rape, and it's false. And the proof of that supposedly is that one juror, wasn't sure. And then he challenged the verdict in front of Judge Kaplan, the judge who presided over the trial. And Judge Kaplan ruling came down yesterday, and man, it is tough on Trump. So Trump says, look, all I was found was sexual abuse. I mean, that could be, touching Carol's breast through her sweater. That's really, not much, and you should get rid of the verdict. Actually, that would be enough to sustain the verdict. But Kaplan just went to town on him and said, look, here was the evidence in front of the jury. Here are the facts. The very least that they had to have found, they could not have found based on the evidence that he grazed her breasts or whatever. They had to have found at a minimum that he penetrated her with his finger. And that was enough for them to go forward. And guess what? Whatever the New York technical definition of rape for purposes of the penal code is, that actual kind of assault does count as rape under common parlance. And Kaplan, cited different sources that basically say when this has happened to someone, they have been raped. So therefore, he says, he denies the motion, saying not only did they not find it was rape, they found that it was rape under that's the only way to construe the jury verdict under the evidence that the jury heard. So, all right. This is something less than a criminal trial resulting in a jury verdict beyond a reasonable doubt that he committed rape. On the other hand, remember, we have already a couple times where judges found that Trump more likely than not committed fraud, and that was in their deciding to apply the crime fraud exception to certain evidence in the case, and therefore pierce the attorney-client privilege. So those were sort of legal, factual determinations. Here you have a judge asserting, basically as a judge, and then also characterizing the factual finding of a jury that Trump is a rapist. Now, it strikes me that is as strong, in many ways stronger, really, because it's based on facts that a jury found, that we infer they had to find. That is in some ways even stronger than finding by preponderance of the evidence that fraud was committed, and yet we have it in pretty common parlance now that Trump has been found to commit fraud. So I don't want to go too far here and say, aha, we now know beyond a reasonable doubt, or however you'd put it, that Trump is a rapist. On the other hand, it's no less a kind of determination, and based not just on what the judge thinks, but the judge's account of what the jury found of rape. And to the extent where people are ready to pull the trigger and call him cite the importance of a court having found that he committed fraud, we now have a court having found that he committed rape. So in some loose way, it's fair to say that, the courts have already determined him to be a fraudster and a rapist. Again, underscoring the distinction between that and proof in a court of law of a criminal charge, but it does seem to me we're as far along on calling Trump a rapist as we are in calling him a fraudster. So we'll see if that has kind of legs and purchase, but definitely the finding of fraud by judges did. And we have something that is, no less strong on rapists. So in general, we're beginning to, even before everything's gone to verdict. Of course, the E. Jean Carroll case is one that has, and there's a new trial where the DOJ is not defending him, by the way, that Kaplan is determined to have in January. All these other things are really piling up. And, when the history books are written, just as they'll say judges found he was a fraudster, I think they'll say a judge found he was a rapist. So, we'll see how far the characterization goes, but there it is out there, and man, is it damning. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.